I'm Dennis Tucker, licensed clinical social worker with New Beginnings Evaluations.
And I'm Julie Tucker. I'm a clinical mental health counselor with New Beginnings Evaluation.
And today we continue our series on custody evaluations. This is our third video. And the topics of today are three. First, how long a custody evaluation should take to complete and how long they usually take. And secondly, what issues and subjects every custody evaluation must address. And lastly, what every custody evaluation may address. And so to begin, let's look at how long a custody evaluation should take to complete. What do you think, Julie?
Well, so that is a very interesting topic. Custody evaluations, when we get them, we are required to finish them within 120 days. However, that is dependent upon us getting a lot of collaboration from the clients. The very first thing that has to occur is we have to be paid after we are assigned. In fact, right now we have a case, Dennis, that we got paid by half of the party in September, and just as of last Wednesday, they're talking about payment for the last half. So that one hasn't even started.
So in other words, that's been about 7 months since the time that one party paid, and now we have information about a second party paying.
Right.
Okay.
So people will ask, well, should we just all wait for everybody to pay? And my answer to that is you really don't want to do that, because part of what happens is when we get paid is also kind of noted in our notes. It doesn't make it or break your custody evaluation, but it is noted. And if the person who is not paying on time and not being responsible also has other indications of being responsible, that does actually affect your custody evaluation. So our advice is pay your custody evaluator as soon as you can, because it looks good for you.
Well, in addition, according to the duration of the custody evaluation, a lot of this is set by law. And so we have certain things that we must do in a timely manner. So in our situation, we really don't have the obstacle of 29 custody evaluations that we're working on, and so we don't have a backlog. And so maybe with some agencies that might be a bit of a problem, but typically it's not. It is set by law, and so as long as things are going according to the flow and the clients are able to do things on their part, then the flow of the custody evaluation actually takes place pretty quickly.
So let me talk a little bit about that. Everybody does custody evaluations differently. Some people have processes that they can really go by. Because we are a group, we take a group approach to our custody evaluations. It's extremely important that we have a process. So we actually are very aware of how long ours do take. So really we should talk about maybe the amount of time that each different thing takes, how much the court requires as far as time, and how much time it takes us versus how much time it might take other people. What do you think? Should we cover that?
Well, then that means that we're on our next step. What issues and subjects every custody evaluation must address?
Actually, no, we're still at the process. So we're actually talking about time, but we'll talk a little bit about the process for sure. So the process and what it does encompass will be part of it, but really I want our viewers to understand really, kind of how long things take. So I'm going to start off by just kind of going from start to finish in a perfect custody evaluation.
Okay, and this is how we do things.
Correct. So I mean, we do follow a standard practice. It's put out by the AFCC. Now people will say, well, are there certifications? How does that work to be a custody evaluator? And we have covered that in previous videos, but in the state of Utah, they actually have kind of a little bit of a hands-off approach where they have minimum requirements, and then it's kind of left up to your provider to be able to provide you with the best care. And we can talk about that in our second part, but first let me address time. So according to the law, we are allowed 7 days from the time that we receive actually it's up to 2 weeks. It's up to 2 weeks from the time that we receive your funds to actually begin the custody evaluation. So if you go to court today and the judge gives us an appointment, we have, I think, I can't remember exactly how many, 72 hours to answer. Do you remember exactly? Anyway, it's about 72 hours that we have to accept the appointment. So we send the appointment or accept the appointment. We send it over to the attorneys, and the attorneys usually will then send it to the court. That is technically when your evaluation has started. We then have 120 days from then to be able to complete the evaluation.
So the clock is running.
Yes, it is running. However, due to people's circumstances, sometimes they're not able to follow through. So that's not necessarily
But in
our
a
fault.
perfect world, what would we do?
Okay, so what happens is we're generally contacted by an attorney, and they ask us, when can you start? So we tell them, well, we're backed up until the last call I got. I told them if they were able to get our money to us by Wednesday, the end of business closed on Wednesday, we would be able to start the evaluation by the following Wednesday. So that gives us a week to start. That now isn't required by law. So we're going back to what do we have to do as compared to what do we do. What a custody evaluator has to do is they have to start your evaluation within 2 weeks of the payment of the deposit. Okay. From there, what generally happens is that the custody evaluator can take that whole 120 days to gather all their information and get it back to the court for your concluding interview.
Okay. And so that's the process. That's
the time frame.
So
Mhm.
we're looking roughly at 4 months.
Yeah, that.
Though it could go less time.
Yes. Now for us, other evaluators may go longer, and again, sometimes more time is requested. So technically, your attorney could go back to the court and for cause ask for more time. So you could have 120 days, and then they could add another 120 days, and it can continue going from there. But assuming that nobody has any issues with the 120 days and everybody's willing to bring forward the information, our agency doesn't have any problems getting it done in that 120-day period of time.
Okay, very good. Have we covered that then?
I think so.
All right. Well, then the second part, what issues and subjects every custody evaluation must address? And that brings us to the sacred 4903 codes.
Right. Okay, so I think actually he was saying that it's rule 4903. It's not a code.
Oh, okay.
So there's rules of the statement of the rule of the custody evaluation. So they have guidelines as to what they would like to see. The first set of guidelines, and we covered this in our last video, but the first set of guidelines really goes into who can perform the evaluation, which if you watched our last video, we went into that very thoroughly. As far as what they require, basically you have your name, address, telephone number, some of the basic identifying information, the name of the evaluators or the evaluator agreed upon, the anticipated dates of commencement and completion of the evaluation, estimation of costs, and then every order requiring the performance of a custody evaluation shall include the parties need to be cooperative. So basically, any information that we're requesting from you is information, if you don't give to us, that can go against you. So basically, the judge is saying to you, hey, we require you to give to your custody evaluations the information requested. So that can be anywhere from emails to voice recordings to just about any information, your school topics, any information we can request. And you've had some experience with that, haven't you, Dennis?
Yes, where we've had phone interviews that were used and other types of things. Perhaps our viewers are interested in knowing what to expect during this process. How many interviews do they have?
Okay.
Maybe we should talk about what we do. It may not be, all agencies may do it a little bit differently, so that part may not be so-called mandated by law.
And that's really actually the point. Part of the point of this is that most of the things that are mandated by law are different than how well, there's a general mandate, which is very general, but then there are ways that every agency works, and our agency has a very specific way in which they work. We, at the beginning of every custody evaluation, we begin off with an orientation. And that orientation is for both parties separately. We'll meet with you and we'll meet with the other parent and let them know what it is that we're going to need throughout the evaluation, including references, releases of information. We'll discuss any issues that you feel like you might have. We'll give you lists of things that we require for you to bring back. A background check is something that we generally require. Now that's not necessarily required by every custody evaluator, but we do require background checks because that becomes an issue, especially a he said, she said issue. So part of what we try to attempt to do is we try to make it so that even if you don't agree with what we have said, that you're not going to have to order another custody evaluation because we have been thorough.
Very good. So after the orientation, then we set up appointments for the clinical interview that takes place with me in this case, where I do psychosocial history and background.
And that takes about how long? How long does that take?
It can take various hours, but we set up the appointments for this and block out the time. Also, we interview the children that are involved. They have an interview with me as well. I ask various questions. I go through a series of questions that we have formatted to give us the adequate information. Give you a chance to present your evidences, and by the way, evidences are important. Things that you may have that substantiate what you are claiming, and so we look at those things. So I do the interviews, and after the interviews, and by the way, how many interviews is that?
Well, for us, we end up doing an initial interview, which is the intake. Then we do an assessment with Dennis. We then, so it's 30 to 45 minutes for both of your initial orientations. Then each of the biological parents will have up to 4 clinical hours with the clinician to be able to talk about the concerns, so the clinician can go over all of the psychosocial that you're talking about. Mm-hmm. After that, there are home visits, and the home visits usually last between 2 to 4 hours, and that's scheduled after the assessment. We try to get as much information in as possible so that we can, at the end of our custody evaluation, really talk to both sets of parents and tell them the concerns we have. After that, we also interview, we say up to 4 references per parent, mm-hmm. But we'll do more. I mean, if they give us more, we'll do more. It's just that sometimes parents give us 14 or more, so we're only guaranteeing in our prices that we'll do 4 of them. They take about half an hour each. So we call up each of the people that you have referred to us. We have a list of questions that we ask them. All of them are asked the same exact questions, so there's really not a whole lot of room for people to be. So what you get on some evaluators is that they'll ask questions, but one person may get drilled, and another person may not really have a whole lot of questions asked, and so that doesn't really give you a very thorough evaluation. Okay. And the court doesn't mandate that. So what they do mandate is that we meet with the parents, that we follow the codes, that we have to ensure safety of the children. And so we're basically talking about 2 different things. What does the court require, and what kind of processes do we do in order to ensure we're getting what the court's asking us for?
And let's keep in mind that we also contact the school and speak with the teachers.
We do.
Collaborative information. And so we look for various ways that we get additional evidences and information. And after we've gathered these things and talked with the adults and then the children, we also do a bit of a follow-up interview at the end.
Well, yes, but before that we have to do a psychometric testing. So people will come to us all the time and they say, well, my partner is narcissistic or my partner is histrionic. They use a lot of clinical words and they like to kind of, well, they're trying to express to us their concerns with the partner. And one of the things we want to do is make sure that the parents are psychologically stable. We also want to be able to rule out claims that are coming in that somebody might just be completely, well, for lack of a better term, off their rocker. So we actually do a series of psychometric testing, and that usually the first one we do is called the PAI, and that one is equivalent to, if any of you have heard of an MMPI, it's equivalent to that. Now let me just tell you the difference, and it's actually important you know this because when you go to a custody evaluator, they should be doing some of this testing. It's not required by the state of Utah. It should be required by the state of Utah, in my opinion, because it becomes an additional forensic evidence that allows us to make an appropriate recommendation.
Right. So we do the testing.
Yes.
And that is very much a part of it.
Right. And so
and both parties are tested
equally. Well, sometimes not as equally, but if, for instance, you're claiming that your child has been sexually abused, we will actually test both parents. It's not just the one. So be prepared that if you're putting out certain ideas as to or claims, that we will check them out. And part of how we check them out is through this testing, because the testing is really hard, especially when you have a group of them, to trick as far as they start showing you if someone's trying to be defensive, if they're lying, all these other things. Plus, all of our clinical assessment that we're putting together really gives us a good image of what's going on.
Okay. So after we gather the testing and we've had these initial interviews and
the home visit.
And the home visit.
So it's all of these things.
And so then what we do is a final interview where we have a chance to address with the adults some of these concerns and give them a chance possibly to, I don't want to use the word defend themselves, but maybe that's what we're talking about, possibly to explain some of these concerns that may have been addressed. And so we give them this chance, and then our interviews are done. And at this time we get to sit down and stew over these various evidences and then make our determination.
Now, here's where clients really get a benefit in the fact that there are agencies that do the group approach. And when you're doing a group approach, you're not just having one individual's ideas as to what might be the most appropriate. You're getting actually two with us, and maybe more, as I said, we have a group approach, and there are things that we can assign to others. So we will sit down as a group and talk about what we think is the best course of action for your particular issue, which is a huge benefit. That way, if one custody evaluator doesn't necessarily like you, or you feel like there's a bias towards gender, we try to take care of and answer all of that by the system that we use. Also, the other thing that you should be aware of is that we request that you give us, so there's a whole bunch of information that attorneys can't use because they're not appropriate for court. We can use that information. We get to look at all your biased emails and all of your texts and all of the things that don't generally go into effect or can't be used when you're talking to attorneys because there's no legal ground. We can, however, use all of that, and we do. So before we even do your last interview, if somebody, we also give all of your references a period of time where they get to talk about how they feel about you as a parent. But we also evaluate all of the information that you have given us before we are ready to go before your attorneys and give the final conference.
Okay, so we're coming down to the end of our time here.
Yep.
And so after we gather this information, then we do a report that's called a summary report that we present to the judge at the settlement hearing. And later, if it's required, then we also do a custody evaluation report. The summary report and the evaluation are actually not the same.
That's right.
They are different. The evaluation actually is a more detailed account of all the things that took place, whereas the summary report, as it suggests, is a summary of the findings. And so that is our process. Anything else we need to cover, or do you feel like we have it?
I feel like we should probably have a break.
All right. So that is it for now, and we'll carry on next time.